Why is it that self-defense, stand your ground, and the castle doctrines are not, they were never meant for Black people, first of all. So I'm going to walk you through kind of a brief history of those laws, and then I'm going to show you some examples. And the thing about these laws, right? Self-defense, castle doctrine, stand your ground, all of them. The thing about them is that they are really at the heart of the American ethos. Let's get into that. So the first thing I want to do is I want to share with you like a 1-minute clip from, okay, I want to share with you guys like a 1-minute clip from Dr. Umar. Now, I love Dr. Umar, right? And people say a lot of things about Dr. Umar, but I'm going to tell you why I love Dr. Umar and why I am gonna share what he has to say on this topic with you, right? So to me, Dr. Umar, right, he is in a very small band of the best Black public intellectuals who is bringing into the collective consciousness things that if he didn't bring them to our attention, if he didn't speak on them the way he does speak on them, we would not know of them. And I will always respect and always love him for that. And in that regard, I compare him to, and I'm talking about Dr. Umar Johnson, who I'm about to share a minute of what he had to say about something. In that regard, I compare him to an Al Sharpton in the 80s. If you remember Al Sharpton in the 80s, right? People loved him, people hated him. He was controversial, his public life, his love life, you know, there was a lot going on with that. But he also, Al Sharpton in the 80s, in the 90s, he also was a public intellectual. He was an advocate. He brought to the public consciousness, to the attention of Black folks, things that we would have missed had he not brought them to our attention. Okay, so for that reason, again, I will always love and respect Al Sharpton, and I will always love and respect Dr. Umar, right? They are men, and that's separate from what they do for the culture. Okay, so I want to play a minute and a half of something that he said in an interview. Let me play this.
You know, Art, if you go back and take a look at the slave codes in all of the original 13 colonies, and if you look at the slave codes in any of the slave states of America, you will find that Black men or women never had a right to defend themselves against a white assailant. You could not fight back against your slave master, nor could you fight back against any white person for any reason. If they rape you, you couldn't fight back. If they hit you, you couldn't fight back. If they steal from you, you couldn't fight back. If they tried to sell your child away illegally, you couldn't fight back. So we need to understand something. White America, going back to the plantation, white America has always felt, Art, that they have absolute jurisdiction over the Black body. This goes back to slavery when they owned us. They owned us. Old habits die hard. And since you have a legacy in this country, a custom and a culture where Black people don't even have the right to protect their own body, you get this situation.
The slave code, right? So what we have now in self-defense law, and why it is often not available to Black defendants, and why some of these cases come out in ways that seem incongruent. Okay, the reason for that starts very early. So what I want to do is I want to show you, right? So self-defense was never meant for Black people, but I want to take you back to the statutes. I want to show you the last 400 years of statutes and how they treated gun ownership of Black people. And then we're going to get, and this is free and enslaved Black people. And then we're going to get into how these gun laws overlap with property laws, which lead to the self-defense problem that we're having right now. Okay, so in 1640, right, so this is almost 400 years ago, right, this law in Virginia said that free, not just enslaved, but free mulattoes, Negroes, and Indians shall appear without arms. And then later, right, the amendment was a total gun ban for all Negroes, right? And it was an act, and this is a quotation from the statute, it was an act for preventing Negroes' insurrections. So the author of this, where you can find these, is the Rhode Island legislature. And the author of this, I think, is named Angel Sosa. I think if you want to find more about this. Okay, 1806, 220 years ago. This is a complete gun and self-defense ban for slaves, right? A slave was denied the use of firearms and all other offensive weapons. South Carolina, 1819. The master's permission is required for gun possession by a slave. Okay, let me ask you, what do you think was the chances of a slave getting permission to possess a gun? In Florida, 200 years ago, slaves and free Black homes could be searched for confiscation of firearms, and this was an act to govern patrols. In Delaware, Delaware required free Blacks who desired to carry firearms to obtain a license from a justice of the peace. Now, this is another, this is an example of pretense, right? We're not saying that you can't have them. We're just putting a process in front of them, right? You've got to get a license from the justice of the peace. What do you think was, what was the chance of that happening? Okay. Same year, Maryland, which is adjacent to Delaware. Maryland entirely prohibited free Blacks from carrying guns. 1833 in Georgia. It shall not be lawful for any free person of color in this state to own, use, or carry firearms of any description whatsoever. You cannot use more absolute language than that. Any free person, any description whatsoever, right? Let's look at a couple more. Here's Texas. In 1840, almost 200 years ago, prohibited slaves from using firearms altogether. North Carolina, slave code, right? These are the slave codes that Umar Johnson was talking about. North Carolina, slave code prohibits free Blacks from carrying firearms on the grounds that they were not citizens. Mississippi, and it goes on and on, forbade ownerships of firearms by both free Blacks and slaves, right? So these laws were created not just for slaves, but also for free Blacks. People think that free Blacks had a much different experience from their enslaved people. Not really, right? And there's a lot of scholarship about this. The life of free Blacks and the life of slaves was not all that different for a host of reasons. The ability to protect your home and your family is only one of the ways that they were the same. 1972, United States, Blacks are excluded from militia, right? So this says that law-abiding males do have the right to be in militia and to own guns. Okay, so this is just the background on gun ownership for Black people. And you see that these go 400 years ago. They are literally baked into the fabric. What are people afraid of? They're afraid that if these people get armed, they're going to stop being enslavable, right? The only reason that Europeans have been able to colonize the entire world is because they had guns first. Now, there were some predecessors to guns, right, to the modern gun, in Asia, but the first thing that could sort of propel itself, and you didn't have to get close to the person, right? Europeans came up with this, and it has allowed them to colonize the entire world. Imagine if some other group had developed guns first, and it could be, I don't know why. People have asked, well, why did white people develop the gun first when everybody had access to develop the gun? The question is, who had the highest dedication to dominating others? And if that's your predilection, if that's your predisposition, you're going to invest in what it takes to figure out how to dominate and conquer and colonize others. But our modern self-defense laws, they were designed to protect white male property owners. There's so much scholarship on this topic. I don't even have time to go all the way into it. But if it's something that you're interested in, study it, because the history is there, the scholarship is there, right? And even right now, white men own disproportionately more guns per capita than any other group. So let's talk specifically about stand your ground laws. These are young laws, okay? People think that stand your ground has been around forever. It has not been around forever. The first stand your ground law in the US was in Florida in 2005, right? So it's just celebrating its 20-year anniversary. Now, most of us, and based on the age of most of my viewers, most of us did a whole lot of living before there were stand your ground laws, right? But the way the culture has embraced these, you would think that they've been around forever. But they are the modern incarnation of a much older sort of American institution. Okay, and even the sort of earliest whispers of this law, you might have heard of laws like real man laws, true man laws. These were what they were called, but even those only came about in the mid 90s, right? And with a history like the one I just read you, when a legislature passes a law called a true man law or a real man law, which men do you think they're talking about, right? They're not talking about the 3/5 of a man, okay? So anyway, so let's call this idea an institution, even though the stand your ground law is only 20 years old. This institution is at the heart of capitalism, okay? It's at the heart of ownership, investment, and property. When you think of the early American legislators, when they were thinking of ownership, investment, and property, who were they thinking of? They were not thinking of Black men. They legislated Black men out of that, in fact, right? Why do I say ownership, investment, and property? The heart of capitalism is the ability to invest in something that you can then own. If you can't own it, you're not going to make the investment in it. Okay? And that's what property is, right? Property says, I own this space. I have the right to exclude you from it, right? At the heart of capitalism is the ability to exclude people from a place. I can buy this place, I can invest in making it great, and I can also keep you out of it, right? So that's at the heart of what we're talking about. So if you ask yourself, who were the early property owners? It was white men. It was never meant, the idea that Black people would ever own property was so foreign to them at the time of the statutes that I just read, going back to the early 1600s. It was never conceived with Black people in mind, first of all, okay? And as we have seen it play out in the courts, the goal of the proponents of this institution and the stand your ground laws that we have right now, the ones that I said are only about 20 years old, these are a product of the NRA. The NRA has been very active in every state where you see strong stand your ground laws. So this really is their baby. And we know that white people own disproportionately more guns than any other group of people, right? So all of this stuff is kind of colliding together. But here's the thing. Because these laws were designed for and by white people, without the notion that Black people would ever be the defender, that Black people would ever have property to defend, that Black people would ever think that they have the right to defend, or that they are worthy of defense, that their bodies, their families, their homes, their land is worthy of defense. This was not in the original conception of these ideas. So how these ideas have been shaped in the courts has been with two goals in mind. The first goal is to protect and preserve the institution of self-defense, but to reserve it for whites. So every case that you see, even the cases that seem completely incongruent, when you view them through that lens, the lens of protecting and preserving the institution of self-defense, while reserving it solely for whites, suddenly all of these cases make sense. When you look at these cases, it's never about the white victim. Honestly, it's never even about the white defender, but it's especially never about the white victim, right? So if we're looking at the Carmelo versus Anthony case, for example, just because that's the most recent one that we have, it was never about Austin. It's never about Austin. The particular victim, the sad story, and rest in peace, Austin. My condolences to his family. You know, he was a kid at the same time, both of them kids, neither one of them deserved what they got. But this sob story that everybody's painting about Austin is just the clothing that the issue is wearing right now. Because here's the thing. Like I said, it's about preserving the institution and reserving the institution for whites. Every single case, you can look through this. But here's the thing. If it were really about Austin, or if it were really about any other victim, if it were really about the death of a white male, right? He's almost more the sacrifice, right? He is the casualty of war. If it were about protecting white lives, I hate to say it, but if that were the case, white people would deal with their suicide problem. 80% of suicides in this country, and the US leads the world in suicides per capita. Certainly in raw numbers. If they cared about white bodies, they would first solve their suicide problem. 80% of American suicides are committed by white men. So let me put this into perspective, right? Every year in this country, there's about 40 something thousand suicides. 80% of them are committed by white males, which means that somewhere between 32, 33, 34,000 white men kill themselves every year. Now, let me put this into perspective. In the US, the number of homicides, the average number, right, the sort of running number year over year of homicides of all people and all kinds of victims is about 15 or 16,000. A high year would be 18,000 homicides of all combinations of victim and murderer. That means that twice as many white men die from suicide alone than the number of all the homicides in the whole country, right? 15 or 16,000 homicides every year, 40 something thousand suicides, 32,000 of them are white men killing themselves, right? So this is never about the victim. This is not about Austin. This is not about any white dead body. It's about preserving the institution for the greater good. If a Black person is going to succeed in a self-defense claim, it has to be so egregious. There can be no gray area. No gray area, right? We certainly saw that with Carmela, where there was a question about what happens. Now we're hearing that a new video has come out that shows, basically shows the entire thing instead of the short clip that the jury was seeing. Who knows what's going to happen with that video? Also with Cyrus Belton, nobody understands how Mr. Chow got off. But if you look at it in the two frameworks, the two lenses that I told you, protecting and preserving the institution of self-defense and reserving it for whites, in this case, in the Cyrus Carmack Belton case, there was no white party, but there was a Black party, right? So if you want to protect and preserve the institution of self-defense, and with all these crazy cases, they're creating the boundaries of that area of law. Right now, future cases can refer back to the Cyrus Carmack Belton case and say the court has found that in situations like this is still self-defense. Right. So they're preserving the institution of self-defense. Right. So they wanted to find that there was self-defense. If you look at the Carmelo thing, yes, they may want to find self-defense, but there's that other piece. They want to reserve it for whites. So every single case, if you put it through that lens, you can find why these cases turned out the way they did. Okay. All right. So I talked about how self-defense is like the confluence of a lot of things that are critical to the American ethos, right? So the first one is obviously the fear of Blacks, right? The second sort of force, and these are all the forces that are sort of coming together to create the perfect storm, which is why we're getting these weird self-defense outcomes. Fear of Blacks dictates so much. And I'm not even sure that this is conscious. I think I think it's unconscious. I think people would describe their fear of Black people as something else, whether it's, I know they wouldn't describe it as fear of Blacks, right? They would describe it as something else, fatigue, for example. Okay. The second force is the right to own, the right to ownership of things, the right to own your space, your place, the right to own your time, the need to dictate to others, right? And the right to exclude. We talked about the property right. The core right in property right is the right to exclude. Then there's the need to dominate others. There's other property rights. And then there's also this fear of retribution, right? A lot of people really believe that if Black people were able to, they really would pay back white people for everything that white people have done. And Black people always say that's not true. Like, one, because it's not our nature, but two, because we literally have other things to do. But that is a real driving fear that leads white people to want to preserve and protect the institution of self-defense. So this is why self-defense, stand your ground, these things are not, at the moment, they are not really available to Black people. But also, if there is any little thing that a Black defender does to get them out, to cause them to waive the availability of self-defense, courts and juries, the media, they will magnify the thing, right? And here's how that looks. Why did well, let me go into this, okay? Why did Carmelo have the knife? This goes back to what I showed you in these statutes here, right? That they shall appear without arms, right? They are denied the use of firearms and all other offensive weapons. So for some reason, a legal knife that is of the right size that he is allowed to carry, the question is, why do you even have it? What is that hearkening back to? It's hearkening back to that a slave is denied the use of a firearm and all other offensive weapons. That becomes the central question. Right? And so this is a long-standing legacy that is so baked into the fabric, right? Same thing with Cyrus Carmack Belton. He gave them something to latch onto to decide against him, which was the gun that he had in his pocket. And then they're like, well, why did he run? Well, he probably ran because he had a gun and he didn't want any trouble. Right? So when we're talking about self-defense, whether it's used against us or whether we're trying to use it, any little thing that we give them to use, they will use it, magnify it, and centralize it in a way that allows self-defense against us to work and robs us of the self-defense, affirmative defense. Okay, so I want to say one last thing, and I think I've been on here going on. Okay, this is the last thing I want to say. So I talked a little bit about the fact that Europeans developed the gun first, and it allowed them to colonize the entire world. So if you think about who they tried to colonize and wipe out before they had the gun, it was the Neanderthals in Europe, okay? The Homo sapiens that we live with now, they, in 5,000 years or so, roughly, they wiped out the Neanderthals. Some people think they ate the Neanderthals. Some people think they breeded with the Neanderthals. We don't know. A little bit of both. But it took them 5,000 years to wipe out the Neanderthals. Well, guns made things much faster. They were able to colonize the world quickly with guns, only because they had them first. Imagine if another group, imagine if when they had gotten to the shores of Africa, if Africans had guns, it would have gone differently. Imagine if when they encountered the Native Americans had guns. Things would have gone a lot differently. So here's the thing. After these people have used their guns to colonize literally the entire continent, the entire world, the entire planet, what do they want to do next? They want to go into outer space. And now, when you run out of things and people to colonize, what do? You go into outer space in order to find something else to colonize. And if there were aliens up there, they would shoot the aliens. In order to find something else to colonize, they have to go intergalactic. Like, there's literally nothing else on Earth to colonize. They have to go intergalactic. So anyway, the thought of you having guns or a Black man having guns to slow down that colonization, that's going to be a non-starter. Okay, so Counsel Gray, going back to slave codes to somehow claim that's the reason Carmelo's self-defense claim wasn't respected by the jury is certainly a stretch. I'm not sure that you were here in the beginning, but yeah, so when gun ownership is prohibited for hundreds of years by Black people, but not by other people, yeah, that is part of the fabric of this country, right? So if they weren't allowed to even own guns, certainly self-defense was not intended for the people who didn't have guns anyway. And there were anti-strike laws that I didn't even get into here. There were anti-strike laws that made it a crime, sometimes punishable by murder, to even raise your hand at a white person. So yes, it goes back to the slave codes, and then it became a part of the Black code, because once slavery was done, there was the Black codes, and now there's modern self-defense, where we're starting to see that no matter when self-defense is used, whether it's the state or the defense, somehow the black guy ends up on the short end of the stick. So is it a stretch? I don't know. I'm not a historian. I'm just telling you what the statutes say, right? You cannot make a law that gives people the right to protect property that they own if they're not allowed to own property, right? Have you heard of redlining? If the self-defense laws say that you can use a firearm to protect property, and one group is forbidden from owning firearms or protecting property, the laws can't be there to protect them. Thanks for those of you that came live. I appreciate you.